Yes. And okay. Mr. Riley, who else do you have?
And then have Henry Griffin.
Have we seen Takia DeMyers?
Yes, she's.
Who's representing DeMyers?
Khalil had spoken to her. I think she'll be represented.
Okay. And this is Mr. Griffin?
Yes, Your Honor.
City of Lansing versus Henry Griffin, 25-01731, appearance please.
Patrick Wood on behalf of the city of Lansing, Your Honor.
Jacob Riley on behalf of Mr. Griffin, who is present tonight.
Mr. Griffin has a failure to stop after property damage accident and the driving while license is suspended. See how we resolving this.
Mr. Griffin is working on getting his license restored. He tells me he cannot get it fully restored until October 3rd. We put that expiration on it for some reason. So our request would be an adjournment until sometime after October 3rd.
What's going on October 30th, you said? Oh, you're paying to pass the fines and you won't be finished until October 3rd? And you're working, correct? 60 days. Please. Do October 21st at 8:30. October 21st at 8:30. I will get your notice to appear. Do you have any questions today for the court? Any additional matters for the record?
Nothing from the city, Your Honor.
No, Your Honor.
Okay, all set. What's Ms. Coyle doing
She's still.
with that lady? Is it King Mile? Do you have an attorney?
No, I don't.
Okay, TJ 2400769.
Yes.
Appearance for the record.
Patrick Wood on behalf of the city of Lansing, Your Honor.
And your name, sir?
My name's Neil Chang Miao.
Okay, today was the date scheduled for a formal hearing. This is for an expired meter.
That's right.
Okay, did you all discuss this matter already?
Yes, we did.
Okay, and has there been a resolution?
I wouldn't necessarily call it a resolution in its entirety. I do believe that this has worked its way up in front of magistrates on here. Not going to put words in his mouth, but in the conversation, he doesn't disagree that there was a violation of the meter in and of itself, but more on the fine and how that's been assessed to him is his issue.
What's the issue?
The issue is that, when I drove my car away, I didn't see the tickets on my car indicating that the meter has expired. That's the first thing. I didn't have the ticket on my car. I didn't know I passed it. Secondly, the first time I received the ticket, that was a $20 to $35 fine. And when I received that ticket, I made a phone call to the parking department immediately, parking service immediately. And the gentleman who picked up the phone told me, oh, well, okay, don't worry, that's a mistake. And then he hung down. So I didn't feel like I need to take any actions at all. So I even throw away the ticket. But a month later, I received I received an official ticket, increased to 65, something like that. Then I began to deal with the court. I even sent an email to explain my situation. That is, I think, on the May 3rd, something like that. And I made a phone call. To court, and I tried to explain my case. And then also they scheduled that informal hearing a month ago with that lady, appearing in the courts a month ago. And
Okay.
yeah, it's not about the money. Actually, even $65, I can pay in full, no problem. I just want to extend a little bit my situation.
I'm waiting to hear.
Thank you very much for your listening.
Yes, okay, so your issue is that you didn't see the ticket.
That's right.
Okay, but I have a picture in the file which lets me know, well, first of all, even before I look at the picture, let me be clear here. I've worked in government in this city in county for a long time. I'm a former assistant city attorney. One of the hardest working departments is gonna be those meter maids, you understand? Okay, they don't care who you are. I remember one time when I was assistant city attorney and the city attorney was illegally parked. The city attorney and the meter maid came out to write a ticket. And the city attorney said, hey, I'm the city attorney. And the response was, we don't care. You understand? I get tickets. If I don't park legally, you're gonna get tickets if you don't park legally. I don't believe that they didn't put a ticket there. They took the time to even take a picture of your license plate, which is part of their procedure when they're leaving the ticket. I don't know what happened to the ticket, sir. I don't know if it blew off. I don't know if someone took it off after it was placed there, but it can't be the responsibility of the city. The other thing is we have invested in these lovely devices, these machines that you can download an app so that you can pay for your ticket to park there for the meter. You don't have to use coins anymore. And that app will alert you when your time, it gives you an update. You got 5 minutes left. The responsibility has now been placed back on you to even further be able to know when your time on your meter is up. So I believe that you were properly ticketed. I don't know what happened after that, but you are responsible for the ticket. There's nothing I can do about that.
That's why I'm here.
Yeah, it looks like
That's why I just
the
explained my
magistrate
case.
even,
You know,
if you had paid it originally, it was $15.
I didn't even know I have a ticket. So the first time I received the ticket from the government, from a city, is 35 already. I was trying to resolve that ticket already. I made a phone call to the, I even keep that in my phone call log in my cell phone
Got it.
to show that I did trying to resolve the problem. I was trying to pay. And if when I made a phone call, if that clerk said, okay, go ahead and pay it, then I will pay it. He said, no problem. So he hand down, and then I said, okay, I don't need to do anything. That's why I didn't pay.
Okay, I don't know who you spoke to. I'm sorry that happened.
Yeah.
Because it didn't get rid of the
If you have
ticket.
the complete record, you show that I sent an email.
I don't get
Explain
computer records.
Oh, I'm so sorry.
Yeah, I wouldn't, I only get the court file, which shows me,
If you want, I probably can forward to you that email to the court, and then the court.
you didn't bring it to court with you today, that you sent an email?
I have this email.
Did you show it to Mr. Aboud?
Yes, you see, I sent an email on May 9th, and then I received the email May 9th, coming back from criminal traffic, and said, okay, you see, good afternoon. This email will serve as a confirmation. The court has received your
Can you
document.
show me what your email was?
Yes. This is my email contact. I was trying to explain it. Yeah, when I received the ticket, I made a phone call to that number that was shown on the ticket. And the parking service phone number on February 13th. I even have the time, I can show you the log. The officer, it's a male officer, pick up the phone, who received my phone call and said to me that my case was a mistake, and he expressed his apologies, and I don't worry about that. And he said that the case was dismissed, and I don't even worry about it. And the phone call lasted just about a couple minutes. And therefore, I have not taken any actions after that. This is the February.
It's similar
13th.
to what you've told Judge here.
Yes, yeah, and therefore I have no, but on May 9th, I received the
District Court.
District Court
received notice about it still doing that stuff.
That's right, and that I made this phone call for this phone number, this is a court number, and the court clerk asked me to call back to the parking service again, But yeah, I got connected and they said, no, the case has out of our office and from the court, so we need to contact with the court to continue it. So
Okay,
the parking
what's
service
going on?
doesn't care about that anymore.
The email represents is pretty substantially similar to what he has told you about the situation. He calls them.
He calls who? The clerk's office or
It's
the
like he-
parking lot?
The first call, I called the parking tickets first. And they said, no, don't worry, and then I dropped.
The parking ticket said, don't worry.
That's right.
Look,
That's
you
right.
were supposed to be showing me an email. They sent you an email and told you, don't worry about it?
No, it's not the email.
Oh.
Email from him to the 54A district court.
Got it. You
General
contacted
email,
the
and
clerk's
then-
office about what? Trying to pay it?
Yeah, I just trying to explain that to the court, and the court said, then if this is the case, then arrange me an informal hearing.
Okay, well, we're here for the formal hearing. I recognize you're saying that someone at the clerk's office said, don't worry about it, but you're gonna need to bring that person here, otherwise that doesn't help me.
Okay, yeah, that's the problem.
Nobody at the clerk's office can just dismiss your ticket for you.
Well, I just explained what I experienced. I have no experience of bringing who pick up the phone, but I can show you the phone log.
I mean, I believe that you made the phone call.
Yeah, we're not
disagreeing with
discounting that
that.
you did that. When can you pay the $50?
I can pay that right now.
Okay, we'll get you the criminal traffic window, and then guess what? Then you'll be all set. But you gotta pay the ticket, otherwise we're just gonna keep coming back here.
So there's no, it's just still $50.
It's $50, it was 65.
Now pay the $50 bond last time already.
I can apply that, and you're all set. Thank you, sir. Okay, City of Lansing versus Takia DeMyers, 25-01594, 25 L2947052. Appearance.
Would on behalf of the city of Lansing?
Yara Khalil on behalf of Ms. Demeyers, who appears to my right.
Okay, Mr. Myers has a new ops and no proof of insurance. How are we proceeding?
Your Honor, it is my understanding that Ms. Demeyers will receive financial assistance shortly for the driving with no operator's license matter to get it reinstated. And so we'd ask to adjourn this out for a week. She's in communication with Marquita of the 54A District Court and Charles, who heads the driver's license restoration clinic.
You know when you're gonna do that? Do you know when they're gonna pay this?
So I talked to Charles on Thursday, and he said he was waiting on an okay from Marquita, and I just went to Marquita before I came here, and she said that she sent him the okay on Friday.
Oh.
So
September 2nd at 1:30. September 2nd at 1:30. Any additional matters for today's record?
Nothing from the city, Your Honor.
No, Your Honor.
We'll get you a notice, ma'am. Thank you. Thank you. Okay, back on the record in the matter of the City of Lansing versus Jodie Gilbert. Okay, so counsel, you were requesting an adjournment, and my concern is whether or not she is able to come back.
Understood, Your Honor. So something that's changed as of today is I got an updated phone number and email address for Ms. Gilbert, which our office did not previously have. And she understands how important it is to get this matter resolved so she can move on with her other life plans.
What mail address did you get? I thought she said she was homeless.
We got a new email address
Oh,
and
email
phone number.
address,
Correct.
okay. Okay, and it's the phone number that ends in 7515, that doesn't work anymore? Okay, and do you know what, you know what it's gonna take for her to get her license restored?
I
Or
was,
get a license, I don't know if it needs to be restored or not.
right, I was going to have her sign up for a nearby license restoration clinic and see if they can help her figure out the steps.
I was gonna say, I don't know what this is that they just offered Mr. Myers, you know, with Marquita and whoever Charles's gave, but that sounds like a really great deal.
I did send her the flyer with Charles's contact
Oh,
information.
okay. So it sounds like you can get in touch with Charles and they can help you.
Thank you.
My concern, ma'am, is that, are you gonna come back to court?
Yeah, I'm here today.
I recognize that. I'm happy to see you here, but we just had a history, and I want to make sure we turned a point in here that you want to get your license.
I had people in my life that I was praying on.
Got it. And you got them out of your life now?
Yeah, well, one of them is my daughter, so
I
I
get
have
it.
grandkids.
Got it.
I don't not realize what she has tried to do and what she has continued to do. I just,
Well, hopefully you work that out. But in the interim, you still got to take care of you and understand that your life is important regardless of what people are doing to you. That's temporary. Your
yeah,
circumstance
I
is
realize
temporary,
that.
okay? I don't ever want to hear
Only a
you.
moment in time.
Yeah, exactly. And things can change. You look good, you're here, you're dressed appropriately and nicely, you're trying to get your stuff together. You got to stay in that vein. You just keep doing that and fight each battle one at a time. If you try to fight them all in your head at the same time, it becomes overwhelming.
Yeah.
Take one at a time. You got resources here to help and assist you. You should also go down to HRCS on the 4th floor if you're looking for any additional resources to help you during this time. Or you know what? Even go down to the 5th floor and ask to speak to Mr. Rosa. Tell him I sent you. Mr. Rosa.
Okay,
He used to work at DHS. He's our eviction diversion facilitator, but
Okay.
he has a wealth of knowledge. He can try to align you with resources for absolutely anything. So go down there, tell him I sent you, and tell him what you're looking for resources and see if he can help get you. I don't know what there is, but he knows. That's why we have him here. Okay? He's on the 5th floor. You
Okay.
get off the elevator, you go to the right, you'll pass his office, you'll keep going. You'll pass the magistrate's office. You'll keep
Okay.
going till you get to the clerk's window and tell them that you want to see Mr. Rosa and they'll point you in the
okay,
direction. Okay?
all right,
And then we'll
thank you.
get you his number as well. I'm gonna get you a next court date. We're gonna get you a notice to appear for that next court date. You stay in contact with your attorney so you can keep them updated as to your progress and what you got going on, okay? Yeah. I can do it, we can do September 2nd at 1:30. September 2nd at 1:30. Do you have any questions for the board?
No.
Okay, we'll get you a notice and you're all set for today. Thank you.
Your Honor, can I just correct the spelling of Ms. Gilbert's name on the record?
Yes.
It is Jodi rather than with a Y at the end.
We will note that on the record. I think they put it wrong in the citation. So. Yeah, it actually was correct on the form. Okay, you're all set. Thank you.
Thank you.
City of Lansing versus Keon Kane, 25-01808, 250-293-9781, and 250-295-0632. Actually, that one's not yours.
Just-
Yes, Council Evans.
Patrick Wood on behalf of the city of Lansing, Your Honor.
Jacob Rowley on behalf of Mr. Kane.
Mr. Kane has a careless driving and the driving while license is not valid or improper. How are we resolving these?
Your Honor, I have to, I guess, confess, I got my wires crossed earlier. I told you Mr. Griffin needed it until October 3rd. In fact, Mr. Kane has that October 3rd deadline. So the request would be an adjournment until after October 3rd.
No, I asked Mr. Griffin. I asked Mr. Griffin on the record. He was like, yeah.
He has fines to pay off. I connected him with.
I'm
the
sure he could
restoration
use the
plan.
time. Okay, so you are paying off fines. I don't hear head nods.
No, Griffin
Yes.
is paying off
Yes, Your Honor.
fines. He has October 3rd.
He has October 3rd, what?
You have to wait until October 3rd. Right. They're telling
Got
me
it.
You can't get it till October.
Oh, you have a suspension until October 3rd. And then is there a process after that that he has to go through, or are they just gonna give him his license after that?
From the letter I received, they're just gonna give me my license back. I have to pay a reinstatement.
We can do October 7th.
October 7th at 1:30,
9:30.
9:30. You have any questions?
That's in person.
You can come via Zoom, but you must be properly clothed with a video and in a position appropriate to handle an official court proceeding. Any other questions, sir? Okay, we'll get you a copy of the Zoom instructions, or you can get them off the court website, okay? You're all set.
Thank you.
Is Carissa Sina here? No?
She is, I think she's attending.
Miss Sina,
Yes.
are you driving?
No, I'm not driving.
Why do I see a steering wheel and not your face?
My camera is broke, so you probably can't really see.
It's blurry, but I could see the steering wheel and not you. I want to make sure you're not driving and that you're prepared for court.
I can't really set my phone. I'm not driving though. I'm just.
Okay, well then you can hold the phone. That's fine.
Okay.
Okay, let's see. Are we ready on her? Does she have an attorney? I don't see that she does. Did you request a public defender, ma'am? This is civil infraction.
No.
so I don't know. Okay, so the prosecutor is gonna need to meet with you to see if there's an offer to resolve this, okay?
Okay.
Hang tight for just a moment. We have some code compliance matters. Okay, I have Advanced Corporation 2500057881. Appearance, please.
Actually, on behalf of the city of Lansing,
Hello, Your Honor. Derek Knox here on behalf of Advancement Corporation.
You need to be stationary and prepared for court. We don't do walking around during courts.
I'm stopping somewhere now. I'm out family vacation, so. Okay.
Okay, let's see. This was a code compliance show cause. Excuse me. How are we proceeding?
Yes, Your Honor. I did speak with Mr. Knox earlier. He just spoke to the code office. This is related to zoning, having struggling with what to call it, a trailer or an RV on which I believe is the old Geyer building up here on Cedar. The use that he's using it for, that he's going to use it for, is more of a security. There's a big mural on the side of the building. I'm going to request the next recess to the next available date. I want to see if there's something. I want to make sure that what we're charging is possibly is against all of our code, and if there's a resolution on this, it's not being used as a residential, is what he claimed. And that may or may not fit in. I would request a brief time to sort that.
If I look at the citation, it says outdoor storage of a recreational vehicle in the R-AR residential adaptive reuse district. Is that where your concern is?
Yes, it is a, if you call it that, but he's using it as it is a RV or a trailer. It's not a drivable one, but He's using it for security purposes because he has a mural that's about, I don't know, maybe 2.5 stories that was vandalized recently, and he had put it out there to let somebody be able to sit in. That's my understanding to police.
Right, but I don't, the way this is cited would make me believe that this is not about how he's using the RV or the recreational vehicle, but that it's being used in a residential adaptive reuse district.
Yes, Your Honor, I understand your concern. And what I'm doing is I would like to request an amendment.
You want time to look into
Yes,
that?
I want to make sure before I put my foot in my mouth or in the city's mouth that what he's using it for is going to fall squarely within get some words against.
September 23rd.
September 23rd at.
If I may, Your Honor.
Yes, you may.
The trailer was put there as Mr. Boo stated because one of the murals was tagged, and the person responsible for the mural, first of all, the city of Lansing paid to get this mural done. They paid tens of thousands of dollars to get it done. So we put the trailer there as a means to secure that whole area to make sure nothing like that happened again, because the artist that did it had to come back and fix the area that was tagged. That trailer, security trailer, has been there for almost over a year. It wasn't until someone that uses our football field complained about it that we started to get all of these complaints and tags on our building from this Zachary Driver guy. But there have been no issues. We had no problems with that trailer being there for over a year as a security trailer to secure that area to make sure that that doesn't happen again. I'm totally open to the city of Lansing paying for a security company to make sure that that doesn't happen again. But since we've had that there, we haven't had any issues.
Why would the city of Lansing, I'm sorry, why would the city of Lansing pay for security detail?
Well, I'm just saying, because that mural was paid for by the city of Lansing. The city of Lansing paid to get that mural done on our building. It was a part of a.
The city of Lansing pays for a lot of things. They're not going to pay for security to protect those things. And just because they may have paid via grant or gift or otherwise for a mural doesn't mean that they're now going to provide security to keep it from being vandalized. The other thing that I need to state is just because you didn't get cited for a year does not mean it wasn't a violation. I don't know if it's a violation or not. The city attorney wants to do his due diligence to make sure that he's moving forward appropriately in this. And so that's why the court's going to give him time to do that, because you shouldn't be cited for something that is not a violation, and that's not wrong. However, just because you got away with it, let's say it is wrong, just because no one reported it for a year does not absolve you from the responsibility of following the code if this is a code violation. I don't know. That's for Mr. Abood to research and then provide evidence supporting for or against to the court. If you believe it's not a code violation, then you have the right to bring your own evidence to show that it's not a violation at the time of the hearing. And I should also advise you that I don't hold actual hearings via Zoom. So if there is going to be a hearing, you would need to appear in person, okay?
Understood.
Because I can't present evidence. I can't receive your evidence that you want to present via Zoom. So that's why it has to be in person. But if you all resolve it, then Zoom is just fine. So September 23rd at 11 works for you, sir?
Yes, that should work.
Okay, we'll see you September 23rd at 11, and hopefully all goes well with the city's investigation to resolve this. Thank you. Let's see. Do we have another code matter or we took it? Oh no. Is it prosperity?
We're going to reset it for 60 days. I spoke with him. I want to give him some time. He said he's been working on it.
We reset. Did he leave? I think we did reset.
He might have left.
Okay.
It might have been reset.
I think that was
kind
reset.
of
Okay, sounds good.
a pretty firm 60 days that if he doesn't get.
Okay,
can't
is,
show me.
I don't see another public defender, so if you want to go and log in to meet with Ms. Sina, and I'll take care of some
Put me in a
civil
regular
matters.
room, I should be.
Very good. Mr. Smith, did he leave?
Yeah, he said he had matters with Judge Ward. He said he was gonna,
What is he doing with Mr. Stitt? Do we know?
he said that he refused to answer questions, and he said that he wants an attorney. He said if we can reset it to schedule it in person.
This is the matter of Lansing Automakers versus DeQuan Stitt, 1102391. Mr. Stitt, are you there?
Yes, ma'am.
Okay, Mr. Stitt, my understanding is that you did go into a private meeting room with Mr. Smith, who represents the Lansing Automakers. This was for a discovery hearing, also known as a creditor or debtor's examination, and that you refused to answer any questions. Is that accurate, sir?
I didn't know who he didn't say who he was or why he was asking these questions. I didn't know. I don't know what's going on. I just showed up to court.
Okay. That makes sense.
So he start.
If you don't know who's asking you questions, I wouldn't give financial information either.
So I started.
This is a creditor. This is a credit or debtor's exam. You owe LAFQ some money, and they're trying to figure out how they're going to get it.
Yeah, I'm trying to figure out how much money and some other stuff too, because some other stuff went on. I'm just trying to figure out how much. I don't know how much they sold my car for, because they sold it and didn't really tell me anything after that, because I tried to pay the bill, and then they sold my car. And then for some ridiculous.
You can contact the clerk's office and get a copy of the judgment.
Okay.
And that should tell you what the judgment amount is for. However, because this is set for an official court proceeding to discover information as to how to procure payment on a debt, I'm going to reset this matter. You'll be required to come in person this time, okay?
Okay, what difference is that going to make?
What do you mean, what difference is it going to make?
What difference does it make if I show up to court and then on Zoom?
Because you're going to handle it in front of the judge this time.
I'm in front of the judge now.
Give me a court date.
September 9th at 2.
September 9th at 10, at 2, in person at the court.
That don't make sense. Oh well.
Yeah, well, it may not make sense to you. It makes sense to the court and to the process. You can appear in person.
I bet it do.
If you don't,
Everything makes
bench warrant
sense.
issue. If you don't, a bench warrant will issue.
Okay, I'll be there. I'll be there.
Thank you. You have a good one.
Still makes sense. That's stupid.
What's stupid is to go back and forth in the courtroom. That's stupid. Which matter are you here for, counsel?
The other ones with Mr. Smith. That's why I kind of stood up. They said he was on Zoom.
Yeah, but I think he left to go to Judge Ward's.
Yeah, he saw him on both documents.
Okay, LAFQ versus Sean Pratt, 16-02319. Appearance, please.
Good afternoon, Your Honor. I'm back here for the plaintiff.
Okay, this was a creditor's exam. Did you all resolve this?
For the most part, Judge. Mr. Pratt showed up. He did give me copies of bank statements and pay stubs. He didn't bring his tax return. He just brought a one-page summary. So I was going to ask the court to put this out in about 3 weeks. If he provides, there's two things that might happen. One, if he provides copies of the tax returns, then the plaintiff will call and cancel the date. Or two, he's about to file bankruptcy. If he does that, the date will obviously automatically be stated. But until then, I guess we have to march forward.
Okay, let's see. Typically filed a bankruptcy, sir?
Yeah.
And how far are you on that?
Here soon, hopefully within about 3 or 4 weeks.
well, we're gonna get you our next bill.
September 9th at 2.
September 9th at 2.
That's how long I have to provide the documents.
Correct. That's how long you have to provide the documents so they can move forward with their process. Now, you're still obviously gonna do what you're doing for your personal finances if and when that takes place and they know the private court, it stays the case, okay? Do you have any questions? Making sure notice to appear, any additional matters?
Your Honor, I just
Again,
need
if you
time.
provide those documents, they will remove the court date, okay? This is the matter of Lafque versus Julie Michel, 17-04393 GC. Is Julie Michel here at all?
Always.
Pratt, was Pratt a physical file or not? Pratt should be. Okay. 17. dash. Was she supposed to turn over documents?
Yes, they were supposed to appear. It was a write-up for me, but without them here, there wasn't much to go over.
This was supposed to be a control date, I believe, for some documents that were supposed to be turned over.
Yes.
And we've not received the documents as you scheduled here. How do you want to proceed?
I'll request a bench warrant.
Bench warrant will issue. And what's the past due amount?
Judgment was 60,500, Judge.
Bond is 10%. Bond can be 10%. Yeah.
I think I'm done. I did see Mr. Smith's name, but they only sent 2.
Yes, I think he appeared on the first one,
Doing the rest on Zoom.
and I don't have his name anymore.
Have a good day.
Have a good one, thank you. Dara, actually, are you ready with Miss
Yes,
Sina?
ma'am.
Okay, Carissa Sina, 25L2950632, appearance, please.
Patrick Abud on behalf of the city of Lansing.
Okay, and Miss Sina has met with you privately. Did you give an offer on this?
Yes, you did, Your Honor. The city is prepared to reduce it from an 11 to 15 feet down to a 6 to 10.
Okay, Ms. Sina, did you want to accept responsibility to the amended civil infraction?
Yeah, that's fine.
That's 6 to 10.
6 to 10, yes. Your Honor.
The fine is $150. When are you paying?
Today?
Okay, you can pay give me 15 minutes. I gotta get this file over to the clerk's office so they can dispose of it in the system, and then you should be able to pay online using your case number, or you can
Okay.
come up and make payment at the criminal traffic window, okay?
Okay,
You're all set. Thank you, ma'am.
thank you.
Wait, did I just give you my, docket as well? Thanks. Let's see here. Did I get all the city matters? I did not. City of Lansing versus Stannislav Kaufman, 25-01923.
Patrick Booth on behalf of the city, Your Honor.
Good afternoon, Your Honor. Jason Katz, P70349, appearing on behalf of Stannislav Kaufman.
Is he present?
He is present in my office here today. He can come
So he's
around.
President. Oh, okay. Today was the date scheduled for failure to stop after property damage accident pre-trial. Let's see. How are we proceeding?
Your Honor, it appears to me that today is the date and time set for the pretrial conference. The matter or the alleged matter that this incident stems from dates back to December 5th, 2019, nearly 6 years ago. I haven't had an opportunity to discuss it with the city prosecutor. I don't know what information is available, if there is any discovery or not. Certainly would like to be privy to it, should there be any discovery available, seeing as this matter, alleged matter, dates back nearly 6 years ago.
Where's your client?
He's here.
I need to see him. Okay, thank you. Okay, did you file an appearance, counsel?
I have not filed an appearance, Your Honor. I tried to file an appearance this morning. However, the case does not pop up on MLive. I was not able to file an appearance electronically.
This wasn't to file an appearance electronically.
Yeah, I tried to file an appearance through MyLive, and the case number did not pop up.
Is your office on my live?
My file?
My file, you're on my file?
My file, I'm sorry.
We don't have, our court is not on my file for criminal, only civil.
My apologies, Your Honor. I was not aware of
and
that.
then, yeah, we don't, yeah, we've not gotten that far. So yeah, we would have to file the old fashioned way for criminal for this. And then I don't know if Mr. Abood has received, their office has received an appearance from you.
I do not see one in my file.
Okay, so I can reset this so that you can get your appearances filed and then get discovery and then see how you all can resolve this.
Okay, Your Honor.
Mr. Katz, do you have contact with our office? Do you know our email?
I don't.
It's going to be city, Addie, so city, CITYATTY at lansingmi.gov. You send it to them. It's the big, that's our big inbox. We'll take care of it from there.
Okay, sounds good. Let me just repeat that. It's city, ATTY at lansingmi.gov.
That is correct.
Okay, no problem.
Okay, does September 23rd at 11 work for you, counsel?
Good for me, Your Honor.
Okay, so we'll continue to that date. Any additional matters for today?
Nothing from the city, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Was Mr. Freeman supposed to be in this room? Is that what's going on?
Yeah, we have to call the jail to log him back in because everybody not moving.
There he goes. He's here. Is this Brandon Freeman?
Yes, ma'am.
Who's his attorney? Okay, this is 16-0319. Let's see. What did I do? Right here. I must have wrote the note in the wrong file. Can you give me that civil file back?
Which one?
Was it civil file? I just I gave you 17. No, I did do it right. That's the one that's picture one. Lafferty versus Julie Michigan, 17-0.
Yeah, that's a warrant.
I put warrant on that one.
Yeah,
Okay.
that's a warrant, yep. Oh, yeah.
Okay, let's see. Discover Bank versus Jayla Williams, 24-08832. Appearance, please. Anybody here for that file? It was Discover Bank versus Jayla Williams. I don't know if there's anybody here from or Discover Bank. Okay, what about this one? Donald Burley versus Kevin Gibson, 24-04412. Your name, sir?
Don Burley.
You're Don Burley. Is Kevin Gibson here?
I'm supposed to meet with that guy and he never shows up. Can I ask you something, Your Honor?
Just one moment, sir. I'm just reviewing the proof of service. Look like he was served on July 20th. I guess in person, personally, and failed to appear. You have a question, sir?
Yeah, this Kevin Gibson guy, I mean, he stole my, PlayStation 5 and the game. I got it for my son. My son's he's extreme bipolar, Pratt syndrome, ADD, ADHD. And I didn't realize what things can do for somebody with ADHD. So I got him the game. It was doctor recommended something like that, keep his mind going.
Okay.
Well, 6 days later, it's missing. Kevin Gibson didn't realize the game had to be hooked up to the internet to play. I thought you just take a home buy game, plug it in. But I don't have internet. And my son was talking to Kevin Gibson on the phone. And Kevin Gibson says, why don't you bring your phone over? I'll show you how to use your phone as a hotspot. And my son, okay. And son spent the night over there, woke up, PlayStation was on the table in front of him, it's gone. The guy claims my son got him fired from work. That's why he took the PlayStation. But the guy says, I know the law, they can't touch me. They come to my house, I got cameras everywhere.
So you got a signed order to seize property.
What's that?
You've got a signed order to go and request, you filed a request to seize property.
Yep, and
That's an official court order.
Like Ramsey, he says, the only thing I can get is a car. If I don't belong to him, I can't get nothing.
Yeah, I mean, you requested it. It's only so much you can get. What we can do at this point is he failed to appear. You said this is the third time. This is I only see the first time where he had a proof of.
Was it just one at a time? Plus this time?
No, you got those were a summons and complaint. You filed a summons and complaint last year, July, it looks like. And then he was supposed to appear, he failed to appear, you got a default. Then you filed a request to seize or attach for the debt, seize property in lieu of, and as you wait for your debtor's exam. This is the first debtor's exam that we set though. And so we can issue a show cause.
What does that mean?
That means we send him notice that he needs to appear and show why he failed to appear today. If he doesn't appear, then I can issue a bench warrant.
Okay, so what's
So
the
you
next
want
step for
to
me?
show cause, and then if he doesn't appear, then we can request issue a bench warrant to get him, okay? And the judgment amount, I think, is $600.
600, and they told me back there or downstairs that any extra stuff, like, you know, like filing fees and stuff.
I don't know if he's gonna even come on the show cause. It sounds like he's not. But let's see. I'm just,
I just paid this Dan guy $30
let's just do the
serving.
bond at $600. Let me see if I can put it over here. Okay, so I am gonna just bypass the show clause. I'm gonna issue bench warrant. I'll grant a bench warrant that is with bond at $600 cash. You go down to the civil department, 1 floor down, 5th floor, go to the civil window. Tell them you need assistance with preparing the civil bench warrant for the judge to sign.
Get a pen I can borrow, or I don't. That's too quickly. Too old, I guess. That's it. Going downstairs to do what now? Window?
You give that to him.
Dang. Better stands in here. Yeah. You get downstairs and do this right now?
Yes.
All right.
You all set?
You all set?
Yes,
Have
thank you.
have a good day.
Attorney or the one who's called Jalen Williams, he's in the break.
For
He
who?
just let me know who's here for that case.
Oh,
Just
okay.
let me- But he's talking to Miss Smith.
To who?
He's talking to Miss Smith right now for the free trial. But Williams. is
Oh,
here.
he's on both of us.
Yeah.
We have Freeman here. Who's ready?
Yes, Your Honor, that would be ready.
You ready? Okay. This is City of Lansing versus Brandon Freeman, 23-00072. Appearance, please.
Thank you, Your Honor. Patrick Wood on behalf of the city of Lansing.
Taylor Wicks, Assistant Public Defender, filling in for Attorney of Record Lauren Sutter on behalf of Mr. Freeman, who is present via Polycom from the AM County Jail.
Okay, thank you. Mr. Freeman has a driving while license is suspended. How are we proceeding?
Yes, thank you, Your Honor. In the interest of justice and to hopefully resolve this matter, before you today, the city is prepared to amend the charge to allowing an unlicensed person.
That is correct, and according to Ms. Sutter's notes, he would be accepting of that offer.
Is that correct, Mr. Freeman?
Is he muted? Yeah. What are he doing now?
Mr. Freeman, they muted you. Can you have the deputy unmute your device, please? Oh, he knows how to do it. Or maybe not.
Nope.
Do you hear us now?
I can hear you.
Okay, very good. Did you want to plead guilty to the amended charge of allowing an unlicensed driver to operate a motor vehicle?
Yes, ma'am.
Raise your right hand. You solemnly, is that your right hand, sir?
Okay.
Thank you. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. You have the right to take this matter to trial, sir, and maintain your innocence. You're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the city prove The charge of driving while license is suspended beyond a reasonable doubt, the right to maintain silence at trial and not have that silence be used against you, the right to testify at your trial, and the right to see, hear, or question any witness called to testify against you, and the right to subpoena witnesses to testify on your behalf. You understand each of those rights that you would need to give up today?
Yes, ma'am.
Okay, is anyone threatening you to get you to give these rights up?
No,
Has there been any promises extended to you if you give up these rights?
no, ma'am.
And do you want to plead guilty because you believe you are guilty?
Yes,
As to the amended charge of allowing an unlicensed driver, how do you plead?
guilty.
Actual basis, counsel.
Thank you. Mr. Freeman, I'm taking you back to January 4th of 2023. Were you on MLK near Pierce Road?
Yes,
Are those roads here in the city of Lansing County of Ingham, state of Michigan?
yes,
Were you driving a motor vehicle and came in contact with law enforcement?
yes, ma'am.
And were you driving a motor vehicle?
Yes,
And was your license suspended?
yes, ma'am, but I just didn't know that it was.
Your Honor, I believe it's factual basis to allowing a suspended person, correct?
Any questions?
As long as it's,
Of the factual basis, I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. It looks like as of July 23rd, he was arraigned, at least in a eviction warrant. Bond was set at $250 cash and no PR. So I'll credit him time, sir.
Thank you.
You're all set, sir.
Thank you so much.
Thank you.
how are we done with this?
We finally are done.
We got a short one next week, I just
We
saw.
get to read the hot box.
Oh, my office isn't much, very much cooler, I tell you.
You're on the city hall side, that's why you gotta be, Judge Ward's area to get AC.
Every time I'm in another courtroom, I recognize how blessed I
you
am to
are.
be in front of Judge Ward in the climate control
Not-
courtroom.
Not this.
Have a good
Have a
afternoon.
good one. If it wasn't for LCC, I wouldn't know what's going on around here.
All their work. All their work.
Yeah. The court's like, y'all on your own walking to
Right.
the garage.
We're not ready on our own walking the hall.
They don't care, but y'all gotta walk down that way to get to the garage
That's
almost,
true.
like, go tell people. Ridiculousness. Okay, let's see here. I think I'm done with this file. I closed the one that, who was it?
The,
Jayla?
yeah,
Jayla's not here though.
right.
Okay. I closed it. I need it sent back to me. Let me see. what's on.
Oh. I have to recreate it.
Okay, Pacific Flats versus Joshua Johnson, 25-00686.
Good morning, Your Honor, or good afternoon, Your Honor. Sumption Hart, P69542, on behalf of plaintiff Pacific Flats.
And this is Mr. Joshua Johnson.
That's right. I apologize. I'm really tired. Work third shift. Confused as to why I'm here since I honored the agreement. So I'm really confused why I'm here, why they're dragging me to court again today.
Judge, if I may respond.
I'm just reading my notes here. I do remember that there was a resolution in the other file, but I don't think that had anything to do with this file. Just you.
That's my lawsuit.
Okay. So why, what do you mean you're confused about?
I'm confused why I'm here today since it was an eviction that was for today, a motion for eviction today. I moved last week. I haven't been in that place over a week. So
This is the file that has your counterclaim, sir.
oh, is it? I
Yes.
thought that was 19.
No, that's today for a motion for summary disposition or summary judgment.
I swore I thought it was the 19th. Well, I have everything I have everything I need then to show my evidence.
No, it's a motion for summary. The 19th is the trial date. But today is a motion for summary disposition to see if we're even going to trial. They filed a motion for summary disposition on July 11th. You were served a copy. You never responded.
I'm sorry, there's so much that's going on with this. I'm doing this all by myself. I wasn't aware that I had to do anything for that. I was thinking everything was going on the way it was still. And every time I would come in, I would ask if there's anything I need to do. I wouldn't get any response. Like, just make sure it's coming through court. That's the only answers I was given.
Okay, essentially their motion states that you had a lease, that your rent was $960 a month. Or at least it was increased to $960 a month. Increased yearly to the newest rental amount of $960 a month, and that the $960 per month was pursuant to express terms of the lease agreement between the parties. It says that you were also responsible for late fees and utilities and all other damages beyond normal wear and tear, and that you failed to satisfy this obligation under the agreement, and that their complaint is for a breach of that. And so you filed a counterclaim. They allege the counterclaim fails to state a valid cause of action. The pleading is vague, conclusory, and does not articulate any coherent legal theory or factual allegations that would entitle defendant to relief. They attach your counterclaim as exhibits. The problem is that you did not respond, so I don't even have your response to did you receive this filing from them?
I might have, I might not have.
When did you move?
When did I move? I moved last Monday on the 4th.
So this would have been filed before you moved out.
But with my ledger and with LHC's proof, I can prove everything that they are saying is completely false.
What?
Prove that all these late charges, all these charges that I supposedly owe, all stems from them stealing $1,400 from me.
Okay, so okay. I'm looking at the counter complaint reason 30/20 for the money they stole December 2025 and before to November 2023. $2,747.17. All the illegal and misappropriation of funds from January 2025 and beyond to March 4th, 2025, $5,000 intentional infliction of emotional distress and ongoing harassment. So you're suing for $10,767.
I was thinking about lost wages too, because I'm here again today, taking time off of work. These people have put me through this ever since October 21st, 2024, when they stole that $1,400 from me. And I have the proof right here. And that's all I've been waiting this 10 months, Your Honor, to do is show my proof.
Okay, there was a joint retrial statement that was served. It said there was no objection to the pleadings at this time. You can't now object in the middle of a summary disposition, counsel. That was the time to object. It says plaintiff and defendant have both filed complaints in this matter. Plaintiff served an answer on defendant's complaint. Defendant has not served plaintiff an answer to their complaint. If there was a concern, the court could have addressed it then. We now have a trial date on the complaint. I don't believe it's the best complaint. I also don't believe that by making or ordering him to rewrite a complaint that we're going to get anything much different than what was written in there. I think if I were to try to make sense of what he drafted, he believes, what she said on multiple occasions, that your client has stolen some money from him. I don't know if the theft is construed from overcharging him rent. I don't know what he means by stolen, it's been stolen. But he has the right to proceed in his counterclaim to prove the stolen. I think that's pretty clear, money that was stolen in December and before from your client. And I'm assuming the only way they could do that was he's alleging that they mischarged him.
That I had money in the account for the rainy day when I moved, and they just took it. First.
You had money sitting in your rent account that they
account, and they just.
Okay, and I think you said that multiple times. Let me stop you there. The 2007 4717, he's saying is for illegal misappropriation of funds. Didn't provide a lot of information about what that means.
Misappropriation of funds is that they have charged me late fees. They have charged me pet fees. They have charged me numerous type of fees that they should never have charged me.
And you're saying that amounts to $2,747.
The $1,400.
You're alleging they charge you $2,747.17 worth of inappropriate late fees and other charges.
Yes.
Okay.
Oh, yeah.
And then he's suing for $5,000 for intentional infliction of emotional distress and ongoing harassment. So there's clearly a question of material fact here. You're saying one thing, he's saying the other. You say he owes the money, he says he doesn't owe money, that he's put money in the account and then it was taken without permission. So this matter is going to go to trial.
Judge, if I may respond, that is correct, that Mr. Johnson has relinquished possession. We did not file for a money judgment, and we do acknowledge that he did move out August 4th. The only matter that remains, Judge, is the summary disposition as counter complaint, which plaintiff did indicate to the court in the joint pretrial statement that plaintiff was anticipating a summary disposition motion. Judge, he hasn't responded. It was mailed to him before he moved out of the unit. I'm requesting that the counter complaints, both of them, be dismissed pursuant to MCR 2.116, G as in girl, A as in apple, I, because he did not file a response, which was due 7 days before today's hearing, which puts us at August 5th. Likewise, Judge, the second counter complaint, he alleges fraud, which has to be pled in particularity, which he has failed to do. So with that, Your Honor, we did indicate to the court that a summary disposition motion was going to be filed. We didn't waive it at that time. I believe that was April 11th, 2025. Yeah, correct. April 11th. We filed this motion timely and he hasn't responded. He can, this would not preclude him from filing a separate civil action against Pacific Flats if he were so inclined. But as far as this case, Your Honor, one, we have possession, so our claim would be dismissed on that. From the termination case, he did relinquish possession as he was ordered to do through your judgment. I'd ask that his counter complaints be dismissed because he failed to respond to the motion for summary.
If I can interject, Your Honor, I've also known that mail has been taken out of my mailbox, and I do know that those landlords have keys to LHC. I even have email from LHC explaining that that mail has not gotten to me. So if that is maybe the case, I don't 100% know. I may have gotten it. I can't say for sure, but I'm doing this all alone. They did steal $1,400 from me.
I understand. You don't have to go over that again. That's your position. I understand your position. That's clear. That's clear even from reading your very minimal complaint. And I've already conceded that I believe that the complaint could have been better pled. But after having Mr. Johnson before this court multiple times, I would have to personally hold his hand to get a better written complaint, I believe. I think that what he put in there is what he continues to say in the courtroom. And he's not an attorney. He doesn't know how to draft a complaint according to the court rules. The court rule also allows the court to give leniency when you have people in pro per. And so I have to treat this as if I was dealing with the small claims at this point and give him some grace, even though he hasn't properly drafted a complaint comporting with the court rules. The other issue is he was allegedly served a motion for summary disposition, it says by US mail on July 11th. And that would be the date also that it was filed with the court. He states that he did not receive, well, I should say, he doesn't know if he received it. I'm sorry?
I've got so much paperwork.
Correct. I recognize that. He did not receive it. He had a responsibility. He did have a responsibility to respond to anything related to this. But as he appeared here today, he thought he was coming, he thought he was just being harassed and hauled in here for something random. He didn't even realize that this is part of the process and that his jury trial date, which he's clearly hinging on, or his big trial date, that is going to be August 19th. He didn't understand that he had been served with anything. So I believe that he didn't know that he actually had something that he was to respond to. That's why I gave him an opportunity to respond on the record, and I read it for him on the record to get his response, which is consistent with everything he said. He believes that there was money that was placed into his account for rental purposes for a rainy day that was taken without his permission and without having been properly accrued, and that money that is owed to him. He also believes that he was charged some overage fees, whether they be late fees or other damages, and that he was charged erroneously. I don't know if it was necessarily fraud, but he believes it was charged in error. And so the court is denying the motion for summary disposition. This will continue to trial on the 19th. You need to bring all of your evidence and have it organized and be prepared to present at that time, okay?
Absolutely.
Any additional matters for today's record?
Judge, are you requiring jury instructions?
You demanded a jury trial?
Yes, but in all honesty, Your Honor, I did that because that's what I was told at the very beginning, 10 months ago to do. I'd be more than willing to drop the jury trial if we could just have you judge
Okay,
this.
he's waiving jury trial. We'll have a non-jury trial on that day.
I'd be more than happy to have you judge it, Your Honor.
Thank you, Judge. And what time on the 19th, Your Honor? Or would it be the same time as the jury trial, or is it set different because it's a bench trial?
It's at 8:15 as well.
Thank you, Judge.
You're all set.
I'm willing to waive my $50 fee for it, but
Thank you.
yes, I got evidence, Your Honor.
Oh, okay, thank you.
I got it. Thank you.
Thank you. What is Mr. Pratt here? Which matter? No,
He was here on.
Is he here for code?
Yes, I told him he was free to go.
Mr. Brett, I don't know why that your the city attorney is gone. That co-compliance matter has been resolved, I believe, for today at least. I think it was reset. I can't hear you.
Do you know when it was reset for? Do you know when it was reset for?
1 second, because I know it was 60 days out.
October 21st.
Are we talking 525 bench?
October 21st at 11.
October 21st at 11?
That's correct.
Oh, okay.
Thank you.
Thank you.
Oh, no problem.
Yep, have
Let's
a good day.
see. You too. Huntington National versus Melissa Loops. Anybody here for that?
That is.
I'm here for Huntington on that one.
That is?
Yeah.
Okay, but Melissa's not here. Melissa Lutz is not here. Let's see. Okay. I think this was the matter that was reset because of the GPS issue. Let's see. The clerk's office tagged this matter. Did I call the case of 25-02022? Counsel, can I have your appearance for the record?
Good afternoon, Your Honor. Thomas Duquette, P82958 on behalf of the plaintiff.
Okay, let's see. She has failed to appear, but this was a matter that the court set for hearing. And I think, did we handle a different one of these last week, counsel?
We did, Your Honor. This isn't the same situation, though. There's no court costs on this file. Huntington doesn't pursue court costs. So it's just the damages amount.
No, I think the issue with the, at least though it's noted on the record for me, is the photo, GPS and photo fee.
Correct. There are no GPS or photo fees on this one. The Huntington National Bank doesn't pursue their court costs, so there's no process server fees here. If the court looks at our default request and sorry.
The proof of service, it said it was $26 plus.
Right, I understand that the proof of service indicates the fees, but Huntington, when they seek their default judgments or any judgments, just collects their damages amount. So here, if the court looks at our default request and entry, we're just pursuing the $12,509.20 for the damages in the case.
Okay, sounds good. I'll notify, and so the clerk's office will note not to flag these for your client anymore.
Understood. Thank you.
All right, thank you.
I do think we have the same issue on the other 2 o'clock that I'm here for. That one is Capital One versus Williams.
Okay, that was the Capital One. You said which one that you were, there was an issue on?
This one is Capital One successor by merger to Discover Bank versus Jayla Williams, 24-08832.
That was the one that I closed out of. Okay, I created it. I just see it. I'll note that file as well, so they can disregard that.
Okay, that one I actually think that we do have the issue on. On that one, we are pursuing the court cost, and I do think the court flagged that one because of the additional fees. On that one, there was 20 in GPS and 20 in photo fees.
That is correct. GPS and photo fee seems to be excessive. Let's see.
And I understand the court's position on the excessive nature of the fees, but just for our clarification's sake, is the court taking issue with the entirety of the fees? You know, the statute says that we're entitled to a $5 fee for GPS and a $5 fee for photo. So are we entitled to one GPS and photo fee each, and then any additional fees is what the court is taking issue with, or is the court more concerned?
I think the amount is excessive. It's $20 for a photo fee and $20 for a GPS fee. I do find that to be excessive, and then especially the mechanism. I guess you can. I know the court will allow you to do it, but that doesn't entitle you to both of those. It just allows it. And charging a $20 GPS fee just because you use GPS, I think, is abusive.
Okay, I think I understand the court's position. And when we submit the amended default judgments, then are we still able to include a single GPS and single photo fee?
Yeah, I would review and approve that. I don't know if the $40 is necessary. We're talking about let's see, a service fee of $89, and half of that almost is just excessive the $40 in fees, GPS and photo, to serve something that it said was 10 miles to get there.
Sure. Like I said, I understand the court's position.
So I think that if you want to get, if you want it to not be flagged, and if this gets flagged by the clerk's office and then sent to us, then $20 GPS fee for a 10-mile would be excessive.
Understood. And yeah, that is my end goal, is avoiding having these flagged.
Okay. So if you want to, then your client on this one does seek fees. If they want to amend it to something probably more proportionate to the service miles traveled, then the court will grant it.
Understood. We will do so. And thank you again for the clarification, Your Honor.
Thank you. Let's see. Did they do their joint pretrial on First American?
Michael Lawrence.
Michael Lawrence failed to appear. First American versus Michael Lawrence, 25-01753, appearance counsel.
Good afternoon, Your Honor. Robert Zelinski on behalf of plaintiff P69250.
State scheduled for a pretrial on a general civil procedure. 2:30 was the call time. It's now 3:30. No one's appeared for Michael Lawrence. How do you want to proceed, counsel?
I guess we request if I could file a default judgment, Your Honor.
Default can be granted. You can file that electronically. Thank you.
Okay. Have a good.
Have a good one. Hope Network versus Christopher Lerma, 25-01962.
In the breakout room.
Oh, they're in the breakout room. Capital One versus Verna Smith, 25-02985. Appearance, please.
Good afternoon again, Your Honor. Thomas Ducat, P82958, on behalf of the plaintiff.
Good afternoon, ma'am. How are you? I'm well. Could you state your name for the record, please? Okay, today was the date scheduled for a pretrial. This is for a general civil matter, and you all met privately. You could have either completed a joint pretrial statement to proceed to a possible trial on this, or you could resolve the matter. How are you all proceeding?
We were able to resolve this one. I can place the terms of the consent judgment on the record if the court would like.
Yes, please.
There are damages in the amount of $3,767.82. Court costs in the amount of $154.10. Altogether, it's a total judgment amount of $3,921.92. However, plaintiff has agreed to accept the reduced sum of $3,137.52. Ms. Smith is going to pay the reduced sum in installment payments, 8 installment payments of $392.19. She'll make her first installment payment on September 12th of 2025. She will make 7 subsequent payments on the 12th of each month thereafter until that reduced settlement amount is paid in full.
Let's see. Give me the total amount that she's going to make payment on.
$3,137.52.
In 8 installments beginning September 12th.
Correct, of $392.19.
That's correct, ma'am?
Yes,
Okay, are you sure that's correct?
that's what he said that he could go down to.
Okay.
So he can although I explained to him that Capital One was taken out, automatic payments all along until September. And,
September of when?
24.
Oh.
When I reached out to them to make a payment on the account, to bring the account up to date, that was a payment arrangement agreement. And so I wasn't aware that they had charged it off, but they told me they had charged it off when I talked to them and I tried to make a payment, which they wouldn't take the payment. And so I offered them a settlement, they wouldn't make the settlement. So the next thing I know, months later, then I get this summons to come to court.
Okay, so you were receiving, or they were taking payments from you and you weren't aware this had been charged off? Is what you're
No,
saying?
not until I called.
Okay.
I went online to try to make a payment.
Okay.
And so and I wasn't able to do it through the account, so I called them and they told me that I couldn't make a payment because it was charged off.
And so are you disputing that the total sum was $3,767 owed?
I know that the sum was $3,000 because I tried to split it up. I mean, I tried to transfer it over to another card that was no interest for like 22 months, but I wasn't aware that the new card didn't transfer the entire balance. And so they sent me a letter and said, well, you can transfer the entire balance. So I didn't know that they did not do that. So when by the time I found out that they had transferred only half of it, then I was way behind. So I transferred the balance back over to Capital One. So that's how it escalated.
Got it. Okay.
I paid them for almost 2 years. They took out payments and they just decided to stop. And when I contacted them, they say, well, the money that we were taking out, which they agreed $60 a month. But when I spoke to them, they said, well, the $60 a month, it only went to
interest probably. Yeah. I believe that.
Yeah.
Okay.
It's like $64 interest every month.
Oh, so you're at this point, understanding how we got there, you're in agreement with the charge off amount now to be $3,137.52.
Yeah, because I don't want them suing my income taxes. I don't think they could. I just have Social Security and pension.
Okay, and so and you're going to make a payment or 8 installments, $392.19.
Yes.
Okay, beginning September 12th. Okay, and this is going to be an installment payment order that will prohibit her from being garnished, correct?
That's correct. It's going to be the payment terms in the consent judgment. I explained that with the current payment arrangement, we don't proceed with wage and bank garnishments. I also indicated that I would waive our right to a tax garnishment and the ability to record a judgment lien as long as she stays current on the installment payments.
Oh, you understand that, ma'am?
Yeah, I don't want a garnishment on my credit.
Okay, so you understand you have the right in this matter to take this to a trial. You could have demanded a jury trial. You understand that? You want to waive that? Okay, and no one's forcing you or threatening you to go into this agreement to have judgment enter into an installment payment order. You understand that? Okay. And counsel, are you seeking for her to sign this, or do you want permission for you to sign the consent judgment on her behalf? Because I already have the terms on the record.
I obtained her email address and I was going to send it to her. If she wants to provide permission to sign on the record, that would be great.
You can email it to you and you can review it and sign it. You can email it to the court right now. We can print it off and you can review and sign it, or you can give him permission to sign with, it'll say with your permission on there, not just your signature, on your behalf. And that way we can get an order to the court. How you feel most comfortable?
I would rather sign it.
She wants to sign it herself. So can
Okay.
you provide that to her? Once you sign it, you got to get it back to him and then he'll file it with the court, okay? If you don't, then he could come in and get a default from you. So make sure you get it back to him so that he can file it, okay? Do you have any questions? Okay, any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you, you're all set.
Have a good day.
One thing I did explain to him, and he said that I could contact them. I explained to him that my husband has dementia, so I don't know what right now we're incurring a lot of expenses. So if there was an issue, could I contact them and we maybe work out some type of agreement?
Okay, and what was the response as to that, counsel?
Yeah, I advised her to just keep us apprised of any situation as it develops and that we would be willing to work with her depending on the circumstances and what she has going on. Just as long as she is in communication with us, we would not have any issue working through things with her.
Okay. Okay, I will note that also in the file. Any additional matters for the record?
Not from plaintiff.
Okay, thank you.
You're all
Thank you,
set.
everyone.
So he's gonna send it to me or?
He's gonna send it